Welcome to Justice Trial Nexus.
On June 2, 2014, the Florida Bar filed a disciplinary complaint against 3 Tampa attorneys at the law firm of Adams and Diaco, equity partners Stephen Diaco and Robert Adams, and non-equity partner Adam Filthout. The complaint arose from events that took place during the firm's representation of radio personality Bubba the Love Sponge Clem in a civil suit brought by rival radio host Todd Schnitt. And Mr. Filthout, along with Mr. Diaco and Mr. Adams, were alleged to have participated in a scheme to have Mr. Schnitt's lead attorney, Philip Campbell, arrested for driving under the influence. Following a disciplinary trial, the referee appointed by the Florida Supreme Court recommended that all 3 attorneys be permanently disbarred. Now, Mr. Diaco accepted the permanent disbarment, but Mr. Adams and Mr. Filthout appealed the recommendation. Oral argument was heard on June 9, 2016, with attorney William Jung representing Mr. Adams, Mark O'Brien representing Mr. Filthout, and attorney Jody Thompson appearing on behalf of the Florida Bar. Mr. Jung presented his arguments on behalf of Mr. Adams first.
The next case on the docket will be the Florida Bar versus Robert Adams. Whenever you're ready.
Mr. Chief Justice, and may it please the court, I'm William Jung, and I'm here with respondent Mr. Robert Adams. We're here on a very narrow grounds. The sole issue presented by our appeal is the finding of permanent disbarment. We do not contest the findings of fact. We do not contest disbarment, and we don't contest any of the findings, what I might call the convictions on the recommended findings of discipline. The issue presented here is simply whether permanent as opposed to non-permanent disbarment is appropriate. As Mr. Adams did below, he comes here and confesses his serious, egregious, ethical shortcomings.
Well, wait a second. What do you say he did it below? I thought it went through a full hearing by the referee.
Yes, it did.
And I didn't think he only testified at the very end. So when did he confess how egregiously wrong the conduct was?
Your Honor, I believe his direct testimony from the stand was that he has never committed such error in judgment in his 47 years on this planet Earth.
Well, I would hope not. I have never, and I don't profess to know everything about the law, but I have never encountered, and I've been in some rough situations, I have never encountered behavior like this, and calculated and planned behavior. This is not okay, I made a mistake. I shouldn't have signed that check. This was a planned, even planned at one time, and it didn't reach fulfillment, and then did it again, or did it, and then even took the files, this law firm. Took the opposing lawyer's files in the briefcase, didn't they?
Well, Mr. Adams wasn't specifically involved in that, but I'm not here, and he instructed me to come not to defend him or to venerate him.
Well, yeah, but you're saying this is just some kind of simple circumstance. This is not simple.
What I'm suggesting and why we are here is because this court's jurisprudence on disbarment versus permanent disbarment suggests that simple disbarment, which is far from any guarantee of readmission, and in fact, as the court knows, the presumption is against readmission should there be an application sometime after 2021. The presumption would be against readmission, but the referee's recommendation of permanent disbarment is inconsistent. I'm here to venerate the court's guidance and the court's precedents, which do not support permanent disbarment.
Well, it could be we've never seen a case this bad.
Well, Your Honor,
is that possible?
Your Honor, I would suggest the cases that we've cited are not as severe as the conduct that occurred with Mr. Adams, as opposed to his main partner, Mr. Diaco, on the case. First of all, the first time they called the police on opposing counsel, Mr. Adams was out of town, knew nothing about it till after. I don't believe Personius was involved in any way. She encountered opposing counsel perchance in a bar, and then she called Mr. Adams. Mr. Adams spoke to Diaco, who said, call Filthout. Filthout was friends, co-respondent and friends with the police officer.
So he knew, again, there's no question, he was intimately involved with the setup to try to get this lawyer arrested.
He was involved.
And he knew the lawyer was a lawyer in a hotly contested case, right?
Yes. Disbarment not permanent to the referee. And that's why the bar, after discovery, said rehabilitative suspension to the referee because of Adams.
When you say rehabilitative, what are you talking?
The bar agreed to a 91-day suspension for Mr. Adams.
At what point?
At conclusion of all discovery.
But not before it went to trial.
Then the referee said no. There was massive publicity caused primarily by Mr. Diaco's inflammatory statements. The referee said no. We went to trial. He convicted Mr. Adams on everything. And the bar then said what I'm saying right now, disbarment not permanent for Mr. Adams, because he was not involved, had no connection to the police officer, didn't know him.
But the problem I see with your argument is that Mr. Adams is the one that the paralegal called on the important night, correct?
She did, yes.
And he knew what had gone on 2 months before, correct?
Correct.
Even though he didn't know beforehand, but he knew after the
yes,
fact
ma'am.
What had gone on 2 months before, and then he made the conscious decision to call them and tell them that he's there now.
To call Diaco.
What did he expect to happen from giving that information?
Your Honor, what I would expect him to happen is he would be disbarred. He would be disbarred like many other lawyers. F. Lee Bailey, who stole from clients and forged judges' signatures, disbarred without permanency. Like this other series of cases where we've seen where someone who makes a horrible mistake is not permanently disbarred. And I've cited the cases. So he should be disbarred, but he should not be disbarred. The permanency cases, and the referee never discussed these. He's not like Norkin, who showed up here and smirked and stared down Supreme Court justices at a public reprimand and was permanently disbarred. He should be entitled to have a chance to be rehabilitated in 5 or 6 years with a presumption against readmission. Thank you.
Later that day, Mr. O'Brien presented his arguments on behalf of Mr. Fieldhout, with Ms. Thompson once again appearing for the Florida bar.
Will be Barr versus Adam Fieldhout. When are we ready?
May it please the court, my name is Mark O'Brien, and I represent Adam Fieldhout. Your Honor, we raised 5 issues before the court on our brief. I'd like to start with the 5th, which is that permanent disbarment is not warranted in this case. As the court in the previous oral arguments started to understand, there are different levels of culpability within the actions of the participants in this case.
Just bring you right to the fact that it sticks out in my mind is that it is your client who knew the police officer, correct?
For 15 years.
And it's your client who got in touch with the police officer both in the first instance and this instance to get the police officer to survey or keep an eye on or let them know when Mr. Campbell was either driving drunk or something, correct? Is that not correct? It was your client who got in touch with the police officer on both occasions?
Yes.
And the police officer lost his career, am I correct?
That is correct.
High price for everyone to pay for this act. Don't you agree?
Without question. Without question.
So also, under the injury, not only the wrongful arrest and incarceration, the disruption of an ongoing jury trial, the discharge of Fernandez, the removal of Officer McGinnis from the DUI squad, dismissal of a significant number of pending DUI case. Are all those correct as far as the injury that resulted from the attempt to gain an advantage in an ongoing trial?
That is factually accurate, as to what the court just stated. What I'd like to point out is that we have an instance where Mr. Fieldhout would not have been involved in this but for the fact that he was very close friends with the officer, Sergeant Fernandez.
Well, that makes it, but I guess, but for, and I don't know what the testimony was, they obviously had this contentious litigation. Mr. Fieldhout was not involved in the litigation, but they must have known, he knew, that Mr. Campbell was a thorn in their side in this high-profile case, correct?
I would suggest to the court that Mr. Campbell and Mr. Stephen Diaco were professionally not fond of each other. I would suggest to the court that Mr. Filtout, in his role as a subordinate, was told to do something by his supervisor on 2 separate occasions.
Are you saying that Mr. Diaco knew about the friendship that Mr. Filtout had with the police officer?
I think that's undisputed by both parties.
It was a personal friendship?
Personal.
And it was Mr. Diaco that he instructed, so it wasn't Mr. Filtout's idea to try to entrap Mr. Campbell?
No, absolutely not. And I don't believe either party will dispute that.
Okay. But at the time this happened, your client had been a lawyer for how long?
At the time, I believe 13 years, 16 years currently.
Been a public defender for a couple of years?
Several years.
He clearly knew, did he not, even the first time, that this was totally flagrantly wrong, what he was trying to do?
Well, I think that let's take the first instance back in November. My client, Mr. Filtout, his sole involvement in that first instance with Mr. Campbell was making one phone call, period. But the intent, what was the intent? Well, I can tell you on behalf of the respondent, his intent was as a citizen informer to...
He didn't testify. How would we know what his intent was? Did he go around? Was he like a pal of Fernandez going around because he really had a thing against DUIs and trying to make sure that anybody that was in a bar, would not drive and drink? I mean, come on.
Sergeant Fernandez testified that Mr. Filtout had given him tips on several occasions regarding drunk drivers. Now, Sergeant Fernandez did not testify at the trial. He invoked his Fifth Amendment right, but he had, as Bar Counsel stated in the previous oral argument, given earlier testimony in separate proceedings.
Mr. O'Brien argues that Mr. Filtout was acting as a citizen informant on the night in question, not as a co-conspirator. On the evening of January 23, 2013, while the Bubba the Love Sponge trial was in recess for the night, a paralegal from Adams and Diaco, Melissa Personius, happened to encounter Mr. Campbell at Malio's Steakhouse near the courthouse. After Ms. Personius alerted Mr. Adams to Mr. Campbell's presence at the bar, she returned to Malio's, where she flirted with Mr. Campbell, lied about where she was employed, encouraged him to drink, and even bought him drinks. Meanwhile, Mr. Filtout contacted his personal friend, Sergeant Raymond Fernandez of the Tampa Police Department, at Mr. Adams's request to alert him that Mr. Campbell might soon drive while intoxicated. According to Mr. O'Brien, Mr. Filtout's conduct was distinct from that of the equity partners, as he simply called his friend at the Tampa Police Department to report a potential drunk driver, just as he had done on several prior occasions. As such, Mr. O'Brien argued that Mr. Filtout was not conspiring against opposing counsel, but passing along information about a potentially impaired driver to law enforcement.
It seems to me every lawyer takes an oath, correct, in this state?
Yes.
And every lawyer is at least charged with knowing the ethical rules, correct?
Yes.
And each lawyer has an obligation to protect his or her own license,
yes.
Correct? And so whether Mr. Philpott was told by Mr. Adams or Mr. Diaco to do something unethical, he had to make the decision about whether or not he was going to participate in something unethical, didn't he?
Yes.
And so it seems to me the fact that it may not have been his idea, the fact that they knew he had this relationship with the police officer does not negate the fact that he chose to participate in a totally unethical scheme.
And that's why I began with the fifth issue and not the first. The fifth issue is whether or not permanent disbarment is warranted. I would suggest to your honors, it is not when you look at the actions of each individual that evening, and more importantly, into the next day.
Wasn't he also a part of all the texting and things that went on that night? I mean, I thought there was like 17 or 18, maybe even 19 different texts between the paralegal and your client. Judge,
I would submit to the court that there were more. But I think it's important to point out when you talk about the text messaging and the phone conversations between Mr. Filtout and his best friend, at the time, Sergeant Fernandez. Sergeant Fernandez has previously testified under oath that a large majority of that conversations related to totally innocuous conversations about paintball, their children. There's a godfather relationship.
We don't know that because what happened to your client's cell phone?
I'll tell you exactly. I'll echo Mr. Jung. What happened is Mr. Diaco hired a third-party lawyer, Lee Gunn. Lee Gunn took possession of all of those cell phones, and that's the extent of the respondent's knowledge of his cell phone. He was ordered to give his cell phone to Stephen Diaco, who then provided all of the cell phones, including the respondents, Ms. Personius, Mr. Adams, to Lee Gunn. And that was done, I believe, at the direct consequence of Judge Arnold's litigation or the Clem Schnitt litigation due to the spoliation letter that Shoemaker Loop served on Adams and Diaco. And that's important to note that Mr. Filtout is often described in the media accounts and even in this trial as a partner. He's not. He is, for lack of a better term, an associate attorney. He is a non-equity partner.
I'm not sure for this situation that matters. And I know we'll look at your other issues, but was he at all involved in the briefcase?
Zero.
Okay. Not involved in any of the public statements?
Zero.
Okay. And was the bar has brought up additional aggravation with a PIP lawsuit in Miami. Anything on that?
Zero involvement.
No other prior disciplinary proceedings?
In 16 years, he has zero other, and it's important to note that he was a public defender, which when you serve in the criminal justice aspect of being a lawyer, especially in the public defender, you're often dealt with unhappy clients. My client has never, ever faced any disciplinary proceeding as a result of any of his years, 16 years as being a lawyer, which I think is very important.
Mr. O'Brien emphasizes that Mr. Filtout has never faced previous disciplinary action. Under the Florida standards for imposing lawyer sanctions, which is the framework the Florida Supreme Court uses to determine the appropriate discipline for attorney misconduct, the absence of a prior disciplinary record is a recognized mitigating factor. Standard 3.1 proves that once misconduct has been established, aggravating and mitigating circumstances may be considered in deciding what sanction to impose. And Standard 3.3 defines mitigation as any factor that justifies a reduction in the degree of discipline to be imposed. The list of recognized mitigating factors in Standard 3.3 expressly includes the absence of a prior disciplinary record. By focusing on Mr. Filtout's years of practice without any prior discipline, Mr. O'Brien seemed to be presenting his client as someone who engaged in a single, isolated lapse, rather than a career-long pattern of unethical behavior.
With regard to the phone, the trial judge determined that at trial, both respondent Diaco and respondent Filtout refused to answer any questions about the destruction of their cell phone messages and are subject to the adverse inference that they too have deliberately destroyed them. Is that the trial judge find that?
Absolutely, sir. And just to follow up on that, there is evidence that Mr. Adams, through his own testimony at the trial, said that he deleted text messages. There is evidence through Melissa Personius' own testimony at a separate proceeding that she deleted text messages. There is evidence that Mr. Diaco took those phones and gave them to Attorney Lee Gunn. There is zero evidence, that Mr. Filtout deleted a text message, destroyed his phone, did anything other than what he was ordered to do by a supervisor, presumably pursuant to a spoliations letter that was sent by opposing counsel in the Clem Schmidt case.
That's not what the trial judge found, though.
I don't believe there's any evidence to support, Your Honor, that Mr. Filtout...
That finding by the trial judge.
I'm sorry?
The finding of the trial judge.
Yes.
All right.
And I say that respectfully.
You're into
Is that
your...
an issue here?
I'm sorry?
Is that an issue here? Is that one of the issues that you've raised, that there was no...
It is.
Substantial competent evidence to support that finding?
It is. If you look to issue number 4, that the referee's findings are not supported by competent and substantial evidence, there is no evidence that Mr. Filtout deleted any text messages or destroyed a phone. There simply isn't. There is a negative inference that the judge makes and uses that as the evidence, and I proffered case law from the United States Supreme Court that states the negative inference alone is not enough, that there needs to be something else. With respect to the other participants, I'd submit that there is. With respect to him, there isn't.
Well,
so I believe that that's
basically, the 19 texts or more texts, you fully admit that the incident, but for Mr. Filthout and his knowledge and friendship with Fernandez, the ensnaring, the entrapping, the unethical conduct of that night would not have occurred. So whatever the text, I mean, I don't know how much worse the text could have been, but unless there's some other conduct, I'm not sure what the additional negative inference is from the text messages. So I guess I'm sort of as a semi-friendly question. What did the judge draw as a result of finding that he had destroyed his cell phone?
Well, the judge ruled two different things. Number one, that he conspired with other people, and then he ruled that Mr. Filthout covered up that conspiracy. And I just suggest to the court that there is zero evidence that he covered up any conspiracy. He didn't, because there's no evidence that he deleted text messages. There's no evidence that he destroyed a phone. In fact, to the contrary, there's evidence through Rob Adams' testimony at trial that Stephen Diaco took those phones and gave him the Lee gun. So I think that that's fairly clear, and I submit to the court that the referee simply got that wrong, and I say that respectfully. As to issue one, I do believe that the respondent was denied due process when the referee denied his motion to disqualify the referee. I do believe, as to issue two, that the referee erred in denying summary judgment. As to issue number three, I do believe the referee improperly relied on facts not in evidence. And as to issue number four, again, we believe the referee's findings are not supported by competent and substantial evidence.
But you do agree that if you get through that just you're not contesting disbarment, or you are? Are you arguing for a lesser penalty than disbarment?
I'm arguing that this individual have an opportunity at some point in the future to reapply for his license to practice law.
Okay, so you're agreeing to, even with all of these, unless we found the judge should have recused himself, that it should be disbarred.
I started off with number 5.
Okay.
And I did so for a reason.
Thank you.
Mr. O'Brien explains that he is not arguing against disbarment, but that Mr. Filthout should have the opportunity to reapply for a law license at some point in the future. Under Rule 3.5.1 of the rules regulating the Florida Bar, a disbarred attorney who has not been permanently disbarred may apply for readmission after a minimum of 5 years or a longer period if specified in the disbarment order. On the other hand, Rule 3.5.1 expressly provides that an attorney cannot file an application for readmission after an order of permanent disbarment. However, as the Florida Supreme Court explained in the 1966 case of the Florida Bar v. Carlson, permanent disbarment is warranted only where an attorney's misconduct indicates that they are beyond redemption and cannot be rehabilitated. Accordingly, Mr. O'Brien's position is that although Mr. Filthout's conduct warrants disbarment, it does not rise to the level of requiring permanent disbarment, and that Mr. Filthout's ability to apply for readmission after a period of time should be preserved. Once Mr. O'Brien had completed his argument, Ms. Thompson presented for the Florida Bar.
Mr. Filthout was the ingredient in this conspiracy that made it work. Without Mr. Filthout's personal, close friendship with a law enforcement officer who trusted him and didn't have a suspicion of what was going on, this would not have happened.
Let me ask you, but here's my question, and it's, we've got one defendant, respondent, that's agreed to permanent disbarment. Another, and was involved in the briefcase incident, which is outrageous from my way of thinking, and also made public statements which revealed the motivation in this and was involved in that lawsuit and was a partner. We have criminal cases, and you look and say at the end when they're sentencing, we got 3 defendants. Sometimes we talk in proportionality about equal culpability. I think in the eyes of the law, clearly he's equally culpable for what happened that night and the setting up. But the question is, in terms of the ultimate sanction, that everybody gets the ultimate sanction so that this will never happen again. The word is, it will never happen. But isn't there some distinction between what Mr. Diaco did as the partner involved in the litigation and Mr. Filthout, and if not, just, and again, I'm trying to understand that, and right now, appreciate the candor that everyone is agreeing their disbarment is appropriate. So could you explain why, you gave us some reasons for Mr. Adams, why for Mr. Filtout?
Yes, Justice Pariente. Mr. Filtout never testified in this case. He had the opportunity to. He had the opportunity to even hear Mr. Adams' testimony, think about it overnight, and yet he still stood firm and refused to testify, to stick together with the co-defendants. Mr. Filtout should not be...
Are we allowed to draw, because this was an ongoing, that his, and I think we do, that the exercise of his Fifth Amendment right, we can, based on that exercise, draw an adverse inference, that he's entitled to no mitigation. But what is, I guess, what's the not testifying? Does that mean he's showing no remorse? What is the significance of that here?
Yes, the significance to the bar is that if Mr. Filtout is allowed to have a lower sanction, he's being rewarded for failing to be forthcoming, to failing to have candor, to invoking his Fifth Amendment. He should not be rewarded for that behavior. There was a lot of aggravation, not just his personal relationship, dishonesty during the disciplinary proceeding.
I guess the bottom line of this whole thing, where you have this groupthink, where this happened. What happened to the old maxim, a lawyer sees this happening and says, guys, I can't do this. This is wrong. I'm out of here. I mean, quit your job, whatever. I'm out of here. I'm not doing this. Whatever happened to that? I mean, I'm just wondering.
Justice Labarge, I take it that that's not just a rhetorical question, but yes, that is exactly the point. All of these attorneys conspired together and committed these acts willingly, knowingly, intentionally for a bad purpose.
Hearing is, well, this guy did this guy didn't do that, this guy talked, this other guy didn't. They're all in this together. And the whole purpose of the whole thing was to damage this other person's reputation, one way or the other, and in there somewhere there was some advantage that they thought they would gain from this. But again, people are talking about doing something wrong, something bad. You're a lawyer. You took an oath. I can't do this. And if it means, hey, I'm not going to be getting a paycheck from this firm tomorrow, fine. Go back to the public defender's office, go to the state attorney's office, whatever. But we don't do this. That's the whole thing here. When I'm talking about who's more culpable, they're all culpable.
I agree with you, Justice Labarge. It's been said that character is who you really are when nobody is watching. And in this case, the respondents, both Mr. Adams and Mr. Filtout, their conduct shows that they have bad character and they should not be allowed ever to practice law again. It's also said that character is who a person really is, but reputation is just who other people think the person is. And even though the respondents had put in as mitigation that they had character evidence in their reputation and the good deeds they had done, that is not enough to overcome the severity and the horrible nature of this, and anything less than permanent disbarment, I would argue to this court, will not be a sufficient deterrent to other attorneys to dissuade them from engaging in similar behavior.
Ms. Thompson argues that any penalty less than permanent disbarment would be insufficient to dissuade other attorneys from engaging in similar behavior. Rule 3.4.3 of the rules regulating the Florida Bar states that a lawyer may be disciplined if they commit an act that is unlawful or contrary to honesty and justice. In this instance, the referee concluded that Mr. Filtout violated this rule by actively conspiring to improperly affect Mr. Campbell's arrest. Here, Ms. Thompson asserted that conduct of this nature reflects a fundamental defect of character rather than a momentary lapse in judgment, and therefore that the sanction imposed must reflect that gravity in order to deter other attorneys from following the same path. As the commentary to Standard 1.3 of the Florida Standards for Imposing Lawyer Sanctions explains, one purpose of imposing sanctions is to educate other lawyers in an effort to deter unethical behavior among all members of the profession. Ms. Thompson's position is that in a case like this one, only permanent disbarment is sufficient to prevent other lawyers from acting similarly. Following Ms. Thompson's argument, Mr. O'Brien was given the opportunity to address the court in rebuttal.
Picking up on that last point, at one point the Florida Bar felt that 91 days was enough to deter other attorneys from this type of behavior. After the trial was over and the respondent was found guilty, the Florida Bar felt that non-permanent disbarment was enough to deter attorneys from this type of behavior. Now, all of a sudden, it is permanent disbarment. I would suggest to the court, and Mr. Chief Justice, I will answer your question because I believe it's very important to you, and that is, an individual can be as guilty as someone else, but that doesn't mean that their punishment must be the same as someone else. There are different roles in the actions of multiple individuals. And because there are different roles, there are often meted out different punishments. Some are higher than others, some are lower than others. When you look at, and I say this not to besmirch anyone, but you have Stephen Diaco over here with the trial bag and the statements to the media and anything that he did that night. He was involved with everyone. He had contact with all the parties. Then you had Robert Adams, who falls below Mr. Diaco. And then at the far end of it, you probably have Mr. Matroni, who was determined by the Florida Bar to be acting at the direction of his supervisors. I'm not telling you that Mr. Filtout is right next to Mr. Matroni. I'm simply arguing that he's not close to Mr. Adams and Mr. Diaco. He's somewhere in the middle. And as a result, I think his punishment should be less than those two individuals, but greater than Mr. Matroni. It's important to note that his only involvement in this is but for the fact that he knew Sergeant Fernandez. Don't you think that was known by the individuals in this case? Don't you think that there's a certain amount of manipulation that was done by Mr. Diaco with everyone involved? And
that's all well and good, but your client is a member of the Florida Bar and had been for over a decade at the time this took place. And he had, as the Chief Justice just said, he could have walked away from this, but he stayed in the mix twice, and I just don't see how he's not as culpable as the others.
Madam Justice, I don't dispute that, which is why I'm not asking for a letter that goes in his file or a suspension of 10 days or even a suspension of 91 days. What I'm asking for is a punishment that essentially meets his involvement in the crime. I'm not talking about culpability.
But the reality is there's not an unlimited range of punishment. I mean, the worst we can give is the permanent disbarment. So the fact that someone did something worse and only can get permanent disbarment, that's just a kind of part of the structure of reality that we're faced with. Now, perhaps if something more could have been done, it would be done, and because there is an extra element of culpability. But we have limited tools available to us. So the question is, though, ultimately, for your client, is this sanction appropriate?
And I would suggest to the court it's not, because what you have is, like as you said, a limited amount of options before the court. And if you're going to assign the worst punishment to the worst actor, that's appropriate. At that point, then you go below. It's like that in the criminal justice.
See, I just don't buy the logic of that, because sometimes people that have been involved in may not be the most culpable are still eligible for the highest sanction that we have available. I don't follow the logic of what you're saying.
And I understand that. I'm simply arguing to the court.
I understand it's an argument.
It is our position that he is deserving of a less punishment than Stephen Diaco, and to the extent perhaps even Mr. Robert Adams. I would also suggest to the court, just going back to the...
You're well over.
Oh, well, then I will suggest to the court I will sit down.
5 minutes there.
Thank you.
Thank you. Okay, the court's in recess. Thank you for your arguments.
All right.
On August 25, 2016, the Florida Supreme Court issued an opinion approving the referee's recommendations in full and permanently disbarring Mr. Adams and Mr. Filtout, describing the attorney's actions as, and I'm quoting, among the most shocking, unethical, and unprofessional as has ever been brought before this court. In addition, the court entered judgment in favor of the Florida Bar against Mr. Adams for the recovery of costs in the amount of $14,558.66 and against Mr. Filtout for the recovery of costs costs in the amount of $14,178.28. This case is a reminder of the foundational role of ethical conduct in the legal profession. The practice of law depends on the trust of clients, the integrity of adversaries, and the confidence of the public in the administration of justice. When an attorney engages in conduct that's designed to manipulate the legal system for personal or professional gain, the harm extends well beyond the immediate victim. It corrodes the trust that allows courts to function, it undermines the willingness of citizens to engage with the legal system in good faith, and it damages the reputation of every other attorney who works honestly within the rules. The Florida Supreme Court's decision in this case reflects the principle that ethical violations of this magnitude are not technical missteps to be corrected through a brief suspension and then a return to practice. Rather, they go to the core of whether an attorney can be entrusted with the responsibilities of the profession at all. Let us know if there is a case or courtroom interaction that you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society.